Virginia Israel Advisory Board. I'm not going to argue all the better places that the monies could be used to better the citizens of our Commonwealth. We've heard many of them today. We agree with them. Instead, I'm going to focus on a single principle that I've tried to uphold throughout my teaching career. Principle that is simple: equality. To avoid favoritism and discrimination in our community and in our education is crucial, and in our environment to better it, it's essential.
Okay, so this is the state of Virginia House of Delegates and Senate. It is their annual budget committee meeting. We are scheduled to speak and provide the notice. Of course, they don't know that that's what we're doing, but we're here to speak on the budget. So again, we're dealing with an emolument violation. That means that the state is paying their employees or their agents to abridge constitutional obligations. You can never pay someone to violate the Constitution. You can't, especially when you receive federal funding. That's why it's a federal emolument, is because the state of Virginia receives federal funding for their justice system. And when they receive federal funding for their justice system, they can't pay those justice agents to violate federal law. They can't, not with federal funding. That's the federal emolument. So the state of Virginia receives grant funding for courtrooms, for jails, for prisons, for employees, for law enforcement. They receive federal funding, and that federal funding is going to be used to pay people to violate the Constitution of the United States. So we are providing the notice to the state of Virginia right now, to the Senate and to the House of Delegates, because this is a joint committee meeting, right? And we're providing this notice to them. So what should happen, right? And I'm not saying this is what will happen, but what should happen is that, remember, the legislative branch is not involved in this particular issue. Yes, they've created a law. Their predecessors have created a law that allows for them to abridge constitutional obligations, but these people aren't aware that there's any problem because they're just going along with the way business is done as normal. But in a courtroom, you have a prosecutor or a law enforcement officer or a CPS agent who is relying upon an inferior state statute that allows them to do something contrary to what the Constitution of the United States guarantees and protects, right? That is an indictment by a grand jury or the preservation of the familial unit, okay? So when a prosecutor, law enforcement, CPS relies upon an inferior state statute that permits them or directs them to abridge their obligations codified in the Constitution for the United States of America, they just committed a crime called deprivation of rights under color of law. What that statute says is that any person who, the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. When they then bring that issue to a judicial officer of the state of Virginia, a judge, and says to the judge, I'd like you to hold this person over for this capital or infamous crime without having indicted by a grand jury, or when they say, Judge, I'd like you to remove this child and adopt him out in violation of the Constitution of the United States, that judge has a duty and a responsibility to ensure that the power that they exercise is consistent with their authority. If they choose to exercise their power based upon a prosecutor, law enforcement, or CPS agent's abuse of power who relied upon an inferior state statute that permitted them or directed them to abridge their obligations codified in the Constitution of the United States, that judge is also depriving of rights under color of law. Willfully or negligently, it doesn't matter. They don't have to know that they're doing it. Simply by virtue of the breach, the crime has been committed. But once the judge does that, now they have established a conspiracy by and between themselves and the agent that has abridged their obligation by inferior state statute. So now we have a conspiracy to deprive of rights, which is when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now the thing is that these senators that are on this Zoom meeting, the state of Virginia senators and the delegates that are on here, and there's quite a few, you guys, quite a few. We'll provide the names of the delegates later on, but there's quite a few of them. Once they are made aware that this budget that is being proposed is going to be used to pay people to violate the Constitution of the United States of America, these legislators are not involved in the base crime. They're not in the courtroom committing this crime. But if they choose to continue to pay these people or approve this budget once made aware of these criminal conditions, now they are depriving of rights under color of law. Now they are a part of the criminal conspiracy, and now they have also committed the emolument violation, because you cannot pay someone to violate the Constitution. The maximum law that accompanies this is that you can't profit off of your illegal acts. No one can profit off of their illegal acts. So if a judge is committing an illegal act, i.e. violating the Constitution of the United States and breaking the law, then if he gets paid to do that, he is profiting off of his illegal acts. That is the maximum law that's accompanied with the emolument violation. All right, so this is what we're doing. We are trying to force the legislative branch to provide oversight, to say, listen, we're not involved in this. We don't have to be involved in this. But if we approve this budget for these people, then hey, we are a part of it now. And that's the point that we're trying to make. This is the last step in serving all of the branches of government within Virginia. That doesn't mean that we're stopping serving them. We're going to continue to bring notices, but this is a necessary step. The reason why is because city councils pay the police department. They're responsible budgetarily for the police. If the police are performing unconstitutional arrests or assisting in the unlawful removal of children, the city council is responsible for that particular emolument. For the county and the county commissioners, they are responsible budgetarily for the sheriff, for the jail, and for the courtroom. If the resources of the courtroom are being used to facilitate the abridgment of a constitutional obligation, they're responsible for it. If the sheriff are going out and executing warrants that is based upon a prosecutor who relied upon relied upon an inferior state statute that allowed them or directed them to abridge their obligations codified in the Constitution, they're committing a crime. Not yet. And third, if the county is holding people over in a county jail, right? Remember what the Constitution says. It says no person shall be held to answer. The violation occurs at the point of holding, right? Who holds the person? That would be the county jail. Held them to answer for that infamous crime without indictment by a grand jury. But who makes the order to hold them? The judge. Now, my question to all of you is, who pays the judge's budget? Who is responsible budgetarily for the judge's budget? That would be the House and Senate, right? Proposed budget of the judiciary comes through the House and is approved by the Senate. That's why we need to serve these people now. And that's why, first of the year here, we're focusing on making sure that we get the state legislators served, because they are responsible budgetarily for the judges all across the country. So all three of these people need to be served, along with the Attorney General, who's responsible for the actions of the agent, which we've already done that in Virginia. Also, Supreme Court, who's responsible for the actions of the judges all across the country. We've already served them in the state of Virginia. So now we've served the city and county of Fairfax, right? So we've served city agent, local government for police, as well as also local government for county. And now we're going into the state legislature to let them know you prepared the budget and approved the budget for the governor, who is responsible for the budget for the prosecutors and CPS, as well as also you prepare and are responsible budgetarily for the judges. And if the judges are committing crimes and breaking the Constitution in the pursuance of their work, you cannot approve this budget. And if you do, you yourselves are now responsible for a crime in and of itself. That's what we're doing, right? So this is now the fourth state that we've served the legislature. This is only the second state that we will have served both sides of Congress. So here in America, remember, every Congress, every state and federal Congress has two sides. It has Senate side and it has House side, okay? We do need to serve both sides as much as possible, but we've only done that in Georgia during a joint Senate and House. No, it wasn't Georgia. It was Delaware. So Delaware, we served a joint House and Senate committee meeting. It was Public Safety Committee meeting. And then this is going to be the second one where we will observe both sides. If we have one agent of the body of men, right, one senator and one delegate from the House, that is sufficient to introduce this issue into the entire Congress, okay? Because remember, notice to agent is notice to principal. Any one of these senators is an agent of the entire body. And so that's what we're doing here. Once made aware, these senators and these delegates have a lawful obligation to, one, report the crimes, to the proper authorities, and 2, notify their co-conspirators of their intent to no longer participate. And the way that they would notify their co-conspirators is by saying, guys, I can't pay you to commit these crimes any longer. That would be the way that the legislature would have to notify their co-conspirators of their intent to no longer participate, provide the oversight, and say, either you guys act lawfully and constitutionally, or I cannot pay you to violate the law anymore. All right. So we have done one service already in 2026. The last service of 2025 was City of Birmingham, but we did County Beaufort, North Carolina. Beaufort. I don't speak this Southern language, so County of Beaufort, even though it's red Beaufort, but hey, that's from one of these Yankees from up north, and not from one of these Southern Jessicas. So, all right, Beaufort, North Carolina. We served on Monday evening, so we've already started services here in 2026. And we're going to continue, guys, until the court stops ignoring this issue and finally agrees to hear this case. All right, we will not stop. This is a necessary next step in the progression to get into the state houses and notify these people who are paying the judicial budget and so on. So I'm going to let Jessica step in here, and she can talk for a few minutes. And no, come on in. Come on in, Jessica. Everybody wants to hear you. Nobody wants to hear me anymore. All right. They've already heard what I had to say. So come on in and tell everybody what's going on.
Oh, my goodness.
Ladies and gentlemen, Jessica Saxton. Yay!
Everybody, Tano is so much better at this than I am.
Oh, my God.
Go check out our Facebook pages. I think I did upload it to TikTok. But in Beaufort County, we did a...
Beaufort, isn't it?
It's Beaufort. Beaufort County is actually where I grew up in. So it was nice going back home and being able to serve an affidavit of criminal conspiracy against a social worker. So go watch that video. We put a card in some flowers. That's how we got, access to the social worker, Samantha Keach, who is known for taking children and facilitating the removal of children unlawfully. Oh, hi guys.
Yeah, TikTok over there.
That's TikTok over here?
TikTok, Facebook, and YouTube.
Oh, okay. So, anyway, the affidavit of criminal conspiracy for social workers. I am going to release that on Sunday during the Zoom meeting. I don't want to release it before because I want to just go over it with everyone. It's yet again another affidavit, but I want you guys to consider connecting with people in your county, and you guys all go and serve on behalf of others, even in the social services. Is it my turn?
No, I was just listening to see who was next. Go ahead.
Okay. So this is a good way to continue in the exposure. I get these messages on Facebook and TikTok and some of the comments that says, you could have done this the same way and been just as effective via certified mail. And I'm here to tell you that legally speaking, possibly. But the exposure doesn't come when everybody's, the exposure doesn't come when nobody knows. Nobody knows that you guys are going out serving. So here's something that I just thought about doing this morning is I use Power Director. I use Power Director to create the videos. I cannot keep up with all of the videos that are coming in with you guys serving your counties in the event that you go and you're serving these affidavits of criminal conspiracy to your social workers. I can't keep up with the videos, so I'm going... Mr.
Luke, next person. We're good.
Is the next person?
Yeah.
So like 6 minutes? Okay. So I'm going to start in the Zooms. I'll start teaching you guys how I put these videos together. Okay? Because the way the algorithms work, obviously we've tapped into these algorithms. Sorry, we're trying to listen to, because they're calling out the names of who's going to speak next. So we've tapped into these algorithms. Obviously they like the videos that we're doing with the text overlays and all the stuff, but it's very detailed in how to put these videos together. I want to teach you guys how to go and do. I don't want to be doing this for the rest of my life.
Mention
So Do what?
Mention scammers too.
Scammers. Oh yeah. Okay. So anyway, that's what's going on. I'll release the affidavit of criminal conspiracy. It's freaking a strong affidavit for criminal conspiracy regarding social workers. You guys can go get with people in your county and go serve them and buy some flowers. So in those flowers, we had some real flowers and a few fake flowers that we put in there. It cost less than $10 to do that, guys. So, and it was worth it. It was well worth it. Also, the recording app, recording video background. Go download that app. It is free. It has not failed me one time. I've been using it now for over a year. You can record video while your screen on your camera or on your phone is completely off. You can send a text message and it's still recording the whole time on your front camera. It's recording video background. Go download that. It's free. That's how I captured Samantha Keach's face, as well as the whole interaction of walking in and providing the notice and everything else. So another thing that I do when I'm recording is I will flip my phone upside down. The reason is because nobody's going to ever think, unless of course they're seeing this video now, nobody's ever going to think that I'm recording you with my phone flipped upside down. But if you notice the angle of an upside down phone, it would rise and capture the faces perfectly, so that way you're not having to hold your phone upright and tilt it, directly. It's anyway, a lot of the videos that you guys see of the interaction that we have when people don't know that we're recording, a lot of those videos I recorded them upside down, and then on Power Director I'll go and flip that so that it's right side up. So just something to start thinking about. It's very unnatural to do this. It doesn't feel normal when you first get started, but this is the type of exposure that we need, guys. So anyway, what else? Let me see if we have questions.
Scammers.
Oh,
Scammers. We need to.
We have a lot of scammers, a lot of people that are continuing to build fake accounts using our profile pictures and names and likenesses. We will never reach out to you asking, hey, have you received an affidavit from us? We always ask you guys to go onto the website, complete either the family survey or just join the movement so that you can get direct communication with us. And whenever I send an email out, it's going out to over 5,000 people that's on our email list right now. So I won't ever reach out to you asking for money. Tanoa will never reach out to you asking for money. We do not represent anyone in cases. And here's another thing. Since I added the witness request list, the list for people to request witnesses to go to court with you and attend court in person, those people who are leaving their phone numbers publicly on that, they're getting messages from people pretending to be us saying, hey, pay me $600 and I'll come to court with you. So it's making it a little bit easier for the scammers to contact you, but I don't want to take that the witness request form, I don't want to take that down, because you guys need witnesses in your area to go to court with you. You need people to go to court and watch what happens, especially in those counties where they don't allow for you to bring your phones in or any type of recording devices, because we've got to have accountability. And you going to court by yourself in an isolated courtroom is not going to bring accountability. So just like in Blount County, Tennessee, when we had over 50 people that came and witnessed the judge violating her constitutional obligations, now we have 50 witnesses, 50 plus, that technically could file an affidavit saying I was a witness to this. And so that's what we're trying to get, is people that are willing in your local area to go to court with you.
Where to
We
donate?
need that. Do what?
Where to donate?
Where to donate?
Where to actually safely donate?
So going back to the scammers, we only have a few ways that you can donate to us. The best way to make sure that you're getting the donation to the right location and it's not going to a scammer is to go to justicewithoutlimits.org/donation, and we have all of our donation links there. Every one of them is there. If somebody sends you something like, send me an Apple gift card, or send me this gift card, or here, donate to
A different tag.
Like, and they're sneaky, guys. They put "we shall be free" with 3 E's at the end on Cash App. So if somebody goes there and accidentally types in 3 E's with Tanoa, it still has Tanoa's logo and everything on there, you would never know. So just please be careful. Go to the website unless if you haven't if you sent money to us, obviously we'll it would pop up as a common friend or whatever on some of these apps. But go to the website, make sure you're sending to the right place.
And just so that we're clear, guys, just so that we're clear, you guys.
Hold on.
There's smoke coming in that said that they're being promoted to panelists, Mr. Chairman. I'm not sure what is going on, but we'll move on. The next name on the list is Heather Sipe, followed by Ashley Ratliff.
Okay.
So 6 more minutes. So I want to be clear, you guys. Remember, you guys are donating to us doing what is necessary to overcome this issue, right? That's what those donations are for. Those donations are not for us to help you on your case. You guys are giving us the flexibility to be able to do what we know is necessary at any given moment, and we might come into your particular area and serve, but there's no promises that that's what's happening. Every day we wake up and we do what God is leading us to do for that day. That's what's making us successful. So any donations that we get is not for an obligation for us to do anything, because we can't be obligated anyway. That would mean that we were practicing law. We're not soliciting. You guys are providing us with what we need because you believe in the work that we're doing and you believe in the effort that we're expending. So you guys are helping to facilitate the work that we do in providing services to the opposing party, and also to collecting the evidence necessary to bring this case into fruition and the proper legal proceeding. Yeah. That's what you guys are doing.
But you're also what?
Don't add to that, because those are the.
Huh? I know. He doesn't want me to add to this, but I'm going to add anyway. The reason why we operate on 100% donation is because there are some families that they don't have any money. But the families who do, the families who believe, the individuals who believe in what we're doing, and they do have extra, then they are able to help nationally.
Yes.
So we're this is why, look, when we've had people that have come in and said, hey, I'll pay you $1,000 to come and serve our county. Actually, one person on a Zoom, and I was like, you know what? No, we're not going to take that money, because it would go against what I and Tanawa are convicted to do, and that is to fight nationally on behalf of everyone. And so if I was in a situation, and I was at one point, if I was in a situation where I did not have an extra $5 or an extra $500 to help promote this, I would hope and pray that there were other people in America that did have extra and that would be willing to contribute on my behalf to help all of us bring our children home, whether they are adult children in prison that are there unlawfully and illegally, or whether they are children that have been taken by CPS, state custody, or some type of judge and removed our right to see our children. So that's another one of the reasons why we do not. That's it.
And remember, guys, that just as Jessica just said, prisoners don't have money. They're enslaved into a system. They don't get paid. They don't have money to be able to get the resources they need to be able to fight for them, for the injustice that's come upon them. Same thing with these children, these 12 million children. People don't have money. Their families are already taxed through child support, through court orders, through just being poor in general. And so now these children aren't getting the resources that they need either. So yes, she is absolutely correct. That those that are donating, just consider yourself donating for those that cannot donate, yes. Right? That you guys are helping those that can't help themselves because they can't get what's necessary. Guys, we're not getting rich off this, right? We don't have a secret bank account. And we're not able to pay for our orthodontist bills or anything else, right? At the end of the day, we are getting just enough money to be able to support this mission. All right, that's all we have. That's all we get. We don't have a bunch of money, right? So I have always believed that that's better, because it gives us the requirement to have to every morning wake up and operate within the parameters of the resources that we have available to us, right? If we had a whole bunch of money, we might be going in a direction that we believe is right, but it's not right by God. So every single day, we are limited to the resources we have available to us, and so that's the benefit of not having a whole bunch of money. But I just want you guys to know that you guys that are donating, you guys have been amazing. Please keep donating. We got to continue to have the resources to be able to finish this. But if you do donate, just consider it donating for those that cannot.
Yeah. Okay. What else? Let me see if there's any questions. Oh yeah, if you are scammed, please take that and report it to the Attorney General, right?
Yes. So we need your help to catch these scammers, you guys. We don't want them out there stealing money from you, and certainly not in our name. These, as far as I'm concerned, this is the scum of all scum. Stealing from people that are already hurting and need help, and giving up their last dollar for that help, in the belief that we and Jessica and I will come and help them, and they're literally stealing tens of thousands of dollars from all of you. So if you guys are scammed, we want to get these people caught. We want them caught. But the way we're going to get them caught is we need people to investigate. We have enough information on them that we're feeding to the FBI right now. And hopefully the FBI is actually investigating. We've had conversations with them numerous times, and they say that they're looking into this because it is a significant amount of money that they've stolen through misrepresenting us. That's identity theft and other things. But if you guys are scammed, or if you have been scammed, I need you to contact the Attorney General's Office of Consumer Protection for your state, okay? Because that's the agency that is responsible for investigating this particular type of crime. Okay, so if you have been scammed or you get scammed, I need you to please contact the Attorney General, the Office of Consumer Protection, and report the crime. I don't care if they're investigating me, because I didn't get the money. But we need the heat to be brought, and the heat comes through the proper agency. I can't report the crimes. All we can do is feed some evidence in to facilitate it, but I wasn't the victim. You guys are the victim. Therefore, you have to report these crimes. I can't do it for you. I can't do it on your behalf, okay? All I can do is the identity theft issue, and we're already reporting that. But we need help from you guys out there at the edge. Contact your local Attorney General, Office of Consumer Protection, and report this particular crime, okay? That also could facilitate you going to your bank or whatever and requesting refund, because now you reported the crime. So we know that people have been scammed for $2,500, $600, $900, $1,200. We know that they're getting a lot of money, and we know that they're doing it under our name with our logo, and they're offering to obligate themselves, us ultimately, to services that we're not offering, that we don't provide, and they're doing it for a lot of money. So if you've been scammed, right, then I would ask you to please go to your Attorney General, right, the Office of Consumer Protection, report that crime. These guys talking about grand juries. Okay, so again, this is the state of Virginia Senate and House of Delegates Joint Committee budget hearing. All right, this is a public hearing with senators, state of Virginia senators, as well as also state of Virginia House of Delegates. Right, this is a joint committee, and we're here to provide notice to them of the unconstitutional conditions. So again, if the state of Virginia's budget that's being proposed right now is going to be used to pay people or facilitate the abridgment of constitutional obligations, then the state cannot approve the budget, because if they do, they will be paying people to break the Constitution, and that in and of itself is a crime. So this is what we're doing to provide another level of service to the actual people that prepare the budget for the judges, right? And prepare the budget for the prosecutors and CPS. Those budgets come from the state. The governor is budgetarily responsible for administrative agents such as CPS and prosecutors, but the Senate and the House is responsible for the budget for the judiciary, right, and all the judges. Nonetheless, this budget being proposed right now is the governor's budget. So this is a public hearing for the governor's budget, but this is a triple whammy here, because not only are we informing the senators and the House of Delegates of the state of Virginia that the governor has money that's allotted within this budget that's going to be used to abridge constitutional limitations. In other words, break the Constitution, break the law, right? Then the governor's budget itself is unlawful, and the Senate and the House cannot approve that budget. That's what we're informing them. But at the same time, we are also notifying the Senate and the House of Delegates that you guys are responsible budgetarily for the judges. And so whatever budget you prepare down the road, you've already been notified. You've already been made aware that that budget is going to be used to pay judges to abridge constitutional obligations. So this is a triple whammy against the governor of the state of Virginia, as well as also the Senate and the House of Representatives, and informing all three of them that they cannot move forward with state budgets as long as that state budget is going to be used to pay people to abridge constitutional obligations. Remember, this is a federal emolument violation because the state of Virginia receives federal funding for their justice system. And if you receive federal funding, you cannot pay people to break federal law. Otherwise, it's a federal emolument violation. And this particular maximum law that accompanies this. You're right.
I'll do it.
Our governor-elect with fixing the underfunded students and staff
Guys, we're up.
based on their needs. Thank you for your time.
Thank you so much, Ms. Young. Ms. Maggio, next two.
This is Katie. Next would be Muriel Hecht, but she has not yet accepted the invitation to be panelist, and I don't see Warren Thomas or Sam Uri. So we're going to go to Jessica Saxton, and then we're going to go to Tanawa Downing.
How do I accept it?
You already did.
Good morning, Ms. Sexton. You're up.
There we go. Sorry about the delay. My name is Jessica Saxton. I'm a civil rights advocate and litigator out of Washington, D.C. I'm here to provide public notice to the Virginia state legislators. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 from the United States Supreme Court. The Constitution for the United States is the overarching requirements that every state must follow. I don't think that any one of you here would disagree with that. States are not able to enact their own alternative legislation and substitute that for the guarantees of the Constitution. That would mean that your state laws are more powerful than the Constitution, and that is simply unlawful. So Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. Unfortunately, the state of Virginia has enacted a law in its inferior constitution that permits your public officials, your law enforcement officers, prosecuting attorneys to charge by way of information as opposed to indictment, and that is simply unlawful. An emolument violation is when you pay a public official to break the law. There are two areas of our Constitution that reinforces this. The first is Article 1, Section 10, and that's where it states that no state shall create a law that shall abridge the obligation of a contract. So police officers, prosecutors, your judges, your sheriff's department, they are all under a contract. That's a contract to perform based on their oath or affirmation that they took to support and defend the Constitution of the United States of America. The second issue regarding the emolument violation and paying public officials to break the law is the 14th Amendment. And that's where it says that no state shall create or enforce any law that shall abridge the privileges or immunities of United States citizens. Privileges and immunities of United States citizens are at a bare minimum those that are enumerated within the Bill of Rights and the first 10 amendments. So Mr. Tanawa Downing, he is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 people that are currently incarcerated right now, today, illegally and unconstitutionally. I am here to make all of you legislative officials aware that paying people to disobey the law, it is a crime, it is an emolument violation, it is unconstitutional, and it is illegal. So I'm asking you honorable individuals to please take a look at Clause 1 of Amendment 5, confirm everything that I'm saying to be true, and then direct all of your public officials to act in a lawful, constitutional manner that is consistent with the obligations that are codified in the Constitution of the United States. I do have a notice that I need to put on the record. Could you please direct me to where I can email this to you?
Thank you so much, Ms. Sexton, for your presentation. Next up, we have Ms. Ms. Robinson. Could you give the next two?
So the next one will be Muriel Hecht. I also tried to promote Tanawa Downing, and she is unaccepted. So if Muriel Hecht isn't there, I'm going to go ahead and go to Carol Bauer.
Thank you. And I'll just make a follow-up statement about this. If you are in the area as a speaker, the system will send you an invitation to accept to come in as a panelist. If you do not accept it on your device, then you cannot. It's not going to allow you to come in as a panelist. So if you see that, please accept it. All right. Next up, Ms. Hecht.
They don't have me. They showing me as Jessica Saxton. I signed in as Tamara.
Ms. Hecht.
I saw Miss Heck a few moments ago, and it appears she walked away for a moment.
Okay. Next.
Here I am.
Oh, she's back. Okay.
You got me?
What next out of yours?
Oh, thank you. You got me? Can you hear me?
Yes, we hear you fine.
Hey, okay. Thank you for this opportunity to address you.
It's still showing
I'm
Jessica Saxton.
Muriel Hecht. I'm the mother
Next
of
out
a
of yours, please.
33-year-old nonverbal autistic man. My husband and I are in our late 70s, and we were very fortunate that we were able to find a supported living environment.
So they said that Tanawa didn't accept, but he accepted, and for some reason it was showing up on his screen as if he was my name, which is weird. They would have a way on Zoom to change your name.
Well, I just signed back in.
Send him a chat. Anyway, guys, so their service was provided. I don't know if you could hear or not, but when I asked them where they could direct me to provide the notice, they just ignored it and moved on. So anyway, we will have to go down and just provide that notice in person, and I'll record that. Provide the physical notice. They've now been made aware. So that's sufficient for them making them aware, but we want to get this on the record. So we'll go and provide the actual physical notice. Man, I thought for a second that I shouldn't mention your name because you were after me.
They were. They're not allowing me to.
So they're not allowing him to send messages either. And he was signed up under his name, of course.
Okay, so.
Thank you so much. Good morning, and thank you for this opportunity, delegates and senators to speak.
I am back on
My name is
TV now.
Carol Bauer.
Like
I'm a
you
fourth grade teacher in
logged
York
on.
County,
That's weird.
and I'm currently the president of the Virginia
All right, so
Here today on behalf of Virginia students and the educators.
make sure. So you guys, I did log in on a separate Zoom and put in my name. She also logged in, separate Zoom link, logged in under her name. So we had two separate accounts, but they heard that, and then you heard them, right? They said that I was next after Jessica, and then all of a sudden I'm not next. And then they said that I'm not on the panel, even though I'm sitting here with it right now. So I logged off, I logged back in, and I just sent them a message saying that I'm on the Zoom, that I'm prepared to come on the panel if I receive an invite. No response back from the panel, but they did say at the beginning that at the end they will allow for anybody that is still on the call to be able to make a comment. We're gonna hang out. I'm gonna hang out and see if they'll call me. It's kind of looking like they're not going to, but nonetheless, we got the notice in. So Jessica got this one in, and good job, Jessica. Yeah, it is what it is, guys.
This is so frustrating. Can you see me boiling over here?
The crappy thing is that I wasn't recording the screen. So,
I was.
Oh, you were?
I was recording.
Well, we got the screen record. Okay, yeah, we got it. And we also have the list of names of the delegates that were on that. I recorded that at the very beginning. So we have the names of every senator and congressman or represent delegate that was on this that heard that notice being delivered. So we'll see if these guys respond or not. All right, but we're gonna hang out here. I'm gonna just leave this on. I'm gonna turn it up. You guys can listen to the comments that are being made. We registered yesterday at around 10 a.m. Registration started at 8 and it went until 4. You know, I don't know how many there's going to be or how long this is going to take, but we're going to stay here as long as necessary to see if they will do the right thing and allow us to provide the comments at the end. Because, you know, the second part is the one that ties in the law and the law issues, because that's when we start talking about the deprivation of rights. That's when we start talking about the conspiracy to deprive rights. That's when we start talking about CPS. Yeah, I was going to throw CPS in on mine as well, and how the CPS budget is also being used to abridge. Nonetheless, the second part is extremely important. Jessica's kind of been doing that when she talks about like the misprision of felony and stuff. These people need to know the actual crimes are being committed, and they need to know what is against them. That we have 41,000 affidavits from actual victims in the state of Virginia that have had these crimes committed against them. We're not trying to take those affidavits and convert them into criminal complaints, but that's the necessary step if this legislative branch does not provide the necessary oversight to correct these unlawful acts. So that's the warning that we're giving to them is, you know, what do you want to do? Do you want to knowingly and willingly engage in this criminal behavior? Because once being made aware of this issue, if you continue to pay them despite awareness, well, that's knowingly and willingly committing those crimes. But that's up to them. All we can do is say this is what the law states. You guys are clearly about to approve a budget that's going to pay for that to occur. And if you choose to continue to proceed despite being made aware of this issue, there is no claim for negligence. There is no claim for, not knowing. You were made aware, and it's lawfully required. So that's what we're trying to do here is put it on to them to make a decision. Do you want to be known as a criminal? If you do, then continue in your criminal conduct. But if you don't, then you must return to established rule of law. You must obey it. And that means that you cannot approve a budget that's going to be used to facilitate the abridgment of constitutional obligations. So I'm going to leave this on. I'm going to turn it up. You guys can listen to the comments being made, and we'll see if at the end they call me to speak.
CCBHC approach. That approach includes the essential building blocks of a strong.
We might look through the comments here, and while we're waiting, we might look through and respond to some. I have a feeling that we're going to be here for a couple hours. So to try to keep some of you guys around, maybe take advantage of our time here. We'll see if we can get some questions answered. All right. So if you guys have questions, you guys can do that. Maybe if you want to call Jessica's phone, what do you think about that?
Yeah, it's fine with me.
You guys want to call Jessica and ask live?
I'll take it off of Do Not Disturb.
You guys want to call Jessica and ask live? Someone please type into the text boxes.
If you guys want to type my phone number in, it's 252-940-8545. And I got my phone on if you guys want to call in, and then you can ask questions live. 252, can someone type that into the chat? We can't type into the chats. 252-940-8545.
These buggers, man.
No, they did that on purpose.
I know they
I
did.
think they changed your name.
They did. Absolutely did that on purpose.
Back to Tanawa Downing.
Okay.
Oh, look, here we go. Hold on, guys. Going back to. All right, Tanner was on. Hold on, guys.
What O'Connor?
Hello? Yes. I am.
Are you up next?
I think so.
Yes, Hello O'Connor from the 1990 district. And I am.
All right, guys. Change of plans.
Yeah.
We'll still take the call whoever called. Hold on.
We allocation.
So we got one person in front, and then they put him back up to speed. So.
Of public benefits. With the income limits, we're not able to keep a job, or
Hold on, guys.
it can only accept part-time jobs with the abolishment and or the reallocation would free up the money into our public infrastructure, like our transportation and education, as well as the ASWAP vouchers. It will help people with disabilities like me to live independently with dignity and have a life like yours. Thank you so
Is this
much.
recording?
Thank you so much, Will O'Connor. Next up, we have
Can you screen record?
Tanawa Downing.
Yeah, I'm recording. I got it.
Tanawa Downing.
Just go.
Yes, I'm here. I need to be released for video. It says I'm unable to.
We hear you just fine.
Okay, it says host is disabled video. If you'd like me to start, I can, but I can't start with video because the host is disabled video, sir.
Okay.
Okay, I got it. Thank you. So my name is Tanwa Downing, and I'm also a civil rights advocate and litigator out of Washington, D.C. I want to provide some clarification to the notice that Ms. Saxton gave just a little bit ago. So this is just for clarification so that you guys understand what it is that we're actually asking from all of you, because that's extremely important. So if this budget that's being proposed, if it's going to be used to facilitate the abridgment of constitutional obligation, or if it's going to be used to pay agents to abridge their constitutional obligations, such as law enforcement, when they choose to rely upon an inferior state statute that allows them or permits them to abridge or to charge by information as opposed to indictment, you cannot approve this budget, because if you do, then that would be the emolument violation. And remember, the federal emolument has to do with the fact that you receive federal funding. The state of Virginia receives that. You can't pay someone to break federal law when you receive federal funding. That's why this is the federal emolument violation. So I want you guys to understand that I have approximately 41,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from within the state of Virginia. These affidavits are not criminal complaints, they're affidavits. These are actual verifiable complaints from victims that have had this particular crime occur to them. These affidavits identify two crimes in particular. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. Now, the second crime is Title 18 subsection 241, which is conspiracy to deprive of rights. What that says is that when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now, the laws of criminal conspiracy with regard to public officials, that's all of you, that states that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined as offense in the action. So upon having been provided this notice to the Senate of the state of Virginia, as well as also the House of Delegates of the state of Virginia, I'd ask you guys to please, let's work together to fix this problem, because you cannot pay someone to abridge their constitutional obligations, and that's what this budget is going to be used to do. By charging by way of information as opposed to indictment, as well as also the unlawful removement of children in violation of the 1987 Roberts versus United States case from the United States Supreme Court. Now, I know that you're going to go to the attorney as soon as we're done. You're going to ask that attorney whether or not what I'm saying is true. And that attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The Supreme Court of the United States has no constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution, because that must be done by an authentic and explicit act of people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that. Clause 1, Article 1 says all legislative power is vested in the Congress of the United States. So I want to leave you with this, okay? Because I want to entice you in the right direction. The United States Circuit Court has identified a two-part test used to determine abuse of discretion. The second part of that test says that any erroneous view of the law is an automatic abuse of discretion. An erroneous view of law would be the near legal contemplation in considering this matter, that you rely upon the lowest form of law, a judge-made ruling, and not the Constitution of the United States of America, the object of which your fidelity is bound. That would be an obvious erroneous view of law. Therefore, if you approve this budget, that would mean that you guys have, in fact, committed an abuse of discretion in accordance with the United States Circuit Court. Thank you guys so much. God bless. Have a great rest of your day.
Thank you so much for your presentation, Mr. Downing. Ms. Robertson, the next two.
We're gonna do Kevin Latham and then Jesse Monroe. And just a heads up that after that, Devin Wieters registered late, but we'll do him. And then we're gonna circle back to anyone and who we might have missed to see if they're able to join the room. But first we have Kevin Latham and then Jesse Monroe.
All right, so
All right.
we got calls.
All right, guys. So I guess we're going to take some calls. All right. So again, we're not saying that things are going to change, but they should.
Mr. Lake, there we go.
This
If things
morning,
were-
I'm talking to you about-
Do you want to just turn that off?
If things work the way that they're supposed to, then as of this moment, the legislative branch would not approve the budget, and they would go back to the agency and say, listen, we can't approve this budget as long as you're violating the United States Constitution, right? Because if we do, then we are going to commit crime, and we are a part of the conspiracy to undermine the laws of the United States. That's what's happening. So I can't say that that's what's going to happen, but that's what's supposed to happen.
So,
All right. So we got some questions here. We'll answer some questions. You guys want to call in, you want to ask questions, we'll answer them. And then we're going to head on down the road. We are in D.C. right now. We are meeting with the toll and roll people, and we have some other things planned with some legislators here, United States legislators, and so we hope to have a good, successful week. Please pray for us that this week is successful. All right.
Okay. Here is the first. Here's the first question. Are you there?
Yep, I'm here. This is Julie Uli in Utah. Hi, Jess. Hi, Tanoa.
Hey, Julie.
For you guys.
Hey.
How are you?
Good.
Good. I just wanted to know if you could repeat how we can participate in our own states, and also when you guys will be back to Utah again.
I'm not sure when we'll be back to Utah.
So Utah is high up on our list because we have not done a parliamentary service yet in the state of Utah. So what I refer to with parliamentary services is serving the legislative branch. So what we're trying to do is we're trying to make sure that we get at least one city, one county, because we have to, right? In order to notify the legislative branch of government for the state, we have to serve a local city and a local county, as well as also the state. All the people are responsible budgetarily for these agents. So Utah is absolutely one of the states that we need to hit when we do the next loop around the country. We just don't know as of this moment when we're going to do that loop. One of the issues is that we have a timing belt problem on the car. We don't want to go very far until we get that fixed. It's dangerous. I don't know if anybody knows about timing belts. I didn't know anything about them until I started researching it. But if this timing belt breaks, it will cause catastrophic damage to the engine, and we will be out of a vehicle. So we are being a little bit cautious as of this moment until we can get that timing belt replaced and make sure that the car is going to be in good shape. I kind of accept that as God saying, okay, you're going to spend a couple weeks here in Washington, D.C., but that's the way I look at things. God's brought us here. And But we do have a plan to do another loop, mostly across the north,
Okay,
because
but what can she do?
oh yeah, go ahead.
No,
Go ahead.
you go.
Well, go ahead. Well, so there's a lot of counties, over 3,000 counties, and how many cities are there across the country? Jessica and I can only do so much. So we have, as of this moment, served over 108 parliamentary services. That's services to city councils, county commissioners. We've done 4 state legislatures. I'm not asking anybody to go into state legislatures. Please let us do that, right? Let us do what we're doing here on the state legislature, because we have practiced this a lot. But what we need help with more than anything else is we need help at the local level, the cities and the counties. There's way too many for us to serve. You guys don't have to serve your own county. You could go to a different county, right? And you could serve there. Hell, you could go to a different state and serve in a different state, because all we're doing, we know that every single state interferes with the familial unit. We know that every single state arrests by way of information and not indictment, right? So every single person out there that wants to get involved and wants to help, we have the script. It's already written. It's in place. We know that it's sound and solid. We've had judges review it. We've had attorneys review it. It is solid, the things that we are saying. This is a legitimate issue, and it's a legitimate crime. Everything we're saying is absolutely true. Remember, you guys, that when the people are silent, we give our consent and we allow government to do things to us that they would not otherwise do, because we don't speak up and speak out and demand that they do it right. But when government is silent on an issue, that is an indication of its guilt, because government has no right to self-defense. Government is absolutely silent on this issue, with the exception of them saying that that's a state issue. The states are able to abridge the Fifth Amendment and so on. That is absolutely a losing argument for all these states. But that is the only response that we've gotten, is that the Fifth Amendment doesn't apply to the states. And that is absolutely factually untrue, because the Constitution of the United States provides limitation of powers to both state government and federal government. And when the state governments are engaged in the criminal adjudication practice or the removal of children, and they're paid by federal funding to do it, then they must comply with federal law in order to receive that federal funding. Otherwise, as you all know, that is fraud, right? That is a crime. Right? And I'd be more than happy to give you guys the statutes if you guys want to know the federal statute, but you cannot pay someone to abridge federal law when you receive federal funding. That's misappropriation of funding, and that is the federal emolument. So we would ask you guys to please get out and serve your local cities and counties. Help us, help you, and let's get this done.
We have a Zoom every Sunday at 4:30 Eastern, and you can find the Zoom link on the website, or you can go to the website and join the movement, or if you're in family court, fill out the family court survey. Both of those avenues will get you on our email list. And we're trying to make it so that the Zooms, we may actually end up having 2 Zooms per week, because there's so many people that come onto the Zooms on Sunday. But that's where we train and we go into detail. You provide the first part along with the notice, the second part along with the service of the affidavits on behalf of the families of people that have been arrested in the counties. And so if you want to join the Zoom, that would be the best way to get you comfortable. Read through the script a couple of times in front of your peers, and then just go out and put these people on notice.
Go ahead.
Real quick, so I know you did come to Utah. How can I follow up with what was put in at that time when you were here, so I can follow up with that specifically, so I know what I'm talking about if I go follow up with what was filed.
Yeah. So the best thing I would say that people could do on that regard would be, I've served, and Jessica and I have served all of the state attorney generals, with the exception of West Virginia, Alaska, and Hawaii. All of them. We've served all the state Supreme Courts with notices, with the exception of West Virginia, Alaska, and Hawaii. West Virginia is coming up here in a couple days. We're going to get them finished and knocked out. So West Virginia, we're not forgetting you, but Alaska, Hawaii, we can't do that without specific funding to be able to do it, because we can't just drive there. So unless we get funding, we're not getting Alaska, Hawaii done. And as you all know, you have to fly into both of those anyway. Juneau doesn't have a road to get into, and certainly can't drive across the Pacific to get to Hawaii. But so the fact that we provide the service, I need to go through and I need to get the dates for everybody so that you know exactly the date that the notice was provided. But I would say that one of the best things that you could do is follow up with the Attorney General and say what is their intentions on responding to this. But remember, once again, I don't expect to see action until the Supreme Court of the United States agrees to hear the case, because it was the Supreme Court of the United States that, at least in the indictment issue in particular, well, actually, we're going to say for both. Let me do the indictment first. So in the case of the indictment by a grand jury, it was the Supreme Court of the United States that in 1884 said that the state of California doesn't have to do an indictment by a grand jury, right? And thus the United States Supreme Court created a ruling that amended the Constitution, removed the requirements, and now the states are relying upon a judge-made ruling as opposed to the Constitution, believing that that's the foundation. So my point is that in the indictment issue, it's the Supreme Court of the United States that's going to have to acknowledge the fact that what their predecessors put into place is unconstitutional. Chief Justice Waite and his court legislated from the bench, overstepped the separation of powers, amended the Constitution, placed their judge-made ruling at the foundation by calling it law, and that is unconstitutional. But it's also the Supreme Court of the United States in this familial issue. Because remember, it was 1987, Roberts versus United States, that established the right of intimate association, meaning that you have the right to have an intimate familial relationship. So that means that it's the Supreme Court of the United States that's going to have to get up and say, listen, courts, we already made this ruling. You all have to follow it. And if the Supreme Court of the United States doesn't have the power to make all of the lower courts obey their rulings, then to what purpose is the Supreme Court of the United States? So this is an issue of, one, the Supreme Court's going to have to admit what they did in the late 1800s, 1884, and the unconstitutional decision that was put into place that violated the Constitution, which we can argue that in our sleep, but they are also going to have to have the power to actually direct all of their agents below them to obey the rulings that they put out. That was the purpose of the Supreme Court, to make a ruling that impacted the operations of all the regional courts. That was the purpose of creating Article 3 of the Constitution. But if the Supreme Court doesn't have the power or the courage to do that, well, then Roberts versus United States is nothing. The right of intimate association is nothing. So this is a decision that the Supreme Court's going to have to make. They're going to have to stop ignoring this, and they're going to have to actually do what they're obligated to do.
Okay, did that answer your question from Utah?
Julie. Yeah, thank you so much. Good talking with you.
We have another person.
God bless. All right. Yeah. Bye.
Don't end it. We have another person on the call. Yeah, just I guess answer that, and then. All right, hold on. We're gonna merge you. Just stay quiet just for a second until we answer this next question. Okay. All right. The second caller, I think you were from Florida.
Yes. Hi. How you guys doing?
Good. How are you?
And Jessica, it's an honor. Thank you so much for the work that you guys are doing.
Yeah, absolutely, brother. Yeah. What can we do for you?
My question was related. It's pretty much similar to what you guys speak about. I'm currently dealing with a case in South Carolina that they were originally charged in with some criminal charges. I asked if it was criminal or civil. They said it was both. And then they offered me a plea deal, which I have to take at the moment. It was kind of the best choice. And I just questioned how are they able to do such a thing, because I recognize how in the plea deal what they do is they go back in time essentially and change the facts of the matter and saying okay, it's this happened, and then they're able to issue a new citation.
Yeah, so there's a lot of things to talk about in what you just said, but I need to be fast. Let me start by saying plea bargains are absolutely unconstitutional. They've always been unconstitutional, and the reason why is because government has obligations in the Constitution. Those obligations exist before the rights, because the main body of the Constitution, Articles 1 through 7, created the obligations of government. That was adopted and ratified by the people on September 17th, 1787. Then the Bill of Rights were adopted and ratified by the people on December 15th, 1791, which means that the duty comes before the right. That's why our rights always derive from another's duty to act. When that judge made a promise that they will do what the Constitution of the United States of America says that they will do, they entered into their office, and that bound them to certain things, right? Whatever the Constitution requires them to do. So Article 3 of the Constitution, it says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where in which the crime is said to have been committed. Where in that does it say that you can adjudicate a crime in any manner other than a trial by jury for all crimes except for impeachment? It doesn't. That is an obligation of government. So the thing is that your rights are inalienable, because before that judge can ask you, do you want to give up your right? That judge has to break the law, break their obligation, violate their oath, right? Because if a judge says to you, do you want to give up your right to a trial by jury and enter into this plea? In order for you to enter into it, that judge has to break the law. Therefore, your rights are inalienable and you can't give them up. This goes back to the rules of civil procedure. The rules of civil procedure says that rules must not conflict with statutes, nor impair the legal rights of the parties involved. Thus, a court has no power to create a rule which would constitute a waiver of a constitutional right. How is it that the state of South Carolina has a rule in place that permits you to waive a constitutional right when the rules of civil procedure say that they can't do that? Because rules cannot conflict with constitutional obligations. So the answer is that what they got you to do was unconstitutional, because the government, the state, had to break the Constitution in order to receive it. Now, we also need to look at the fact that what they did was they abused their powers in order to get you to enter into a contract of guilt with them, right? That's what a plea bargain is. It's a contract of guilt. You are agreeing to change your legal relationship with the state, and the way that they got you to do it was through an abuse of power. Now, the Fifth Amendment is what we want to go to identify where the actual constitutional violation occurs for plea bargains. The Fifth Amendment's self-incrimination clause says, no person shall be compelled in any criminal case to act as a witness against themselves. Notice, any criminal case, not just infamous crimes, not just capital crimes, but any criminal matter, right? That includes misdemeanors. Now, what the self-incrimination clause says is no person shall be compelled in any criminal case to act as witness against themselves. The definition of compelled is to bring about through the use of threats or intimidation. So if you threaten or intimidate someone in order to get them to act as a witness against themselves, that would be obviously a violation of the self-incrimination clause. Well, in a plea bargain, down at the bottom of it, it says, I did certain things, and you sign it, which means that you are acting as a witness against yourself. In fact, you're the only witness, and the way that they got you to do it is through the use of threats, intimidation, coercion, or duress. If you don't plead guilty, I'm going to send you to prison for 20 years, or I'm going to lock you up in a jail and hold you here until you admit that you're guilty. Those are all abuses of power in order to get you to contract with them, and that is unconstitutional. The last thing I want to add to this is that a lot of people say that when you walk into that courtroom, you grant that courtroom jurisdiction, right? And therefore, you have the freedom to contract. That is true. We all have the freedom to contract, and you did freely contract with them, allegedly, even though that contract derives from the use of duress, and duress is a justifiable defense for a crime, a breach of contract, or a tort. So that is a fully breachable contract that they entered into because they threatened you, right? And you entered into that contract as a result of the duress that they inflicted upon you. However, what everybody needs to understand is that that is not true. Just because the court called you in and said, well, you walked into the courtroom, now we have jurisdiction. No, jurisdiction comes as a first duty to the state and the court. Jurisdiction is statutorily imposed by the Constitution of the United States of America. So if the court, the state, doesn't have jurisdiction, then so what if you walked in that courtroom? That jurisdiction exists before you have the ability to give it up. Therefore, absent jurisdiction, anything that court does is void, wholly without force or effect, because that court never had the authority to even call you in. You can't walk in and grant the court jurisdiction because jurisdiction exists before you're called into that court. If a state takes action in a case in which they lack jurisdiction, nothing that court does is lawful because that court never had the authority to do any of it. Therefore, don't buy into the bullshit that people say that if you walk in courtroom, you're granting them jurisdiction because that jurisdiction exists as a requirement to that state before you can walk in. Furthermore, you can never create a contract by breaching a contract. So if the state has contractual obligations codified in the Constitution, in other words, you don't have jurisdiction, or you didn't have it indicted by a grand jury, when they breach the terms of the first contract, the Constitution of the United States, in order to enter into a contract with you for a contract of guilt, that makes that contract of guilt void, because you can never breach one contract to enter into a second contract. So what I can say to you, brother, is that everything that they're doing to you right now, whether it appears to be or not, is going to be void. Once we finish the work that we're doing, everything that they've done to you is void, because the state of South Carolina had no lawful authority to be able to do the things that they're doing because of jurisdiction, because of duress, because of breach of contract, because of the absence of indictment by grand jury. But count which one of the constitutional violations they committed that will ultimately result in the void judgment at the end. So thank you so much, brother. I hope that answered your questions.
Yeah, thank you so much. That did answer my question. And with that being said, honors, and thank you again. And I would love to file a claim in the state of South Carolina or Florida if you guys haven't done. I would love to also represent and continue the movement, expand.
Thank you.
Yeah, God bless, brother. Love you, man.
Be sure you
Keep your chin up.
Be sure you go to the website, Justice Without Limits, and sign up on Join the Movement, and then you'll get emails from me.
Will do.
Okay.
Thank you so much.
Thank you. Okay, caller number 3, you're up.
Hi. Yeah.
Oh, hold on. Give me just a second. I'm gonna merge this call. Okay, the individual that just called in, you're caller number 4, but we're gonna answer caller number 3. Okay?
I've been following you guys for a long time, so I'll make it quick. My wife is being into a grand jury trial, and she was driving, and they pulled over pretextual. They start threatening her, telling her she didn't tell them what was in the car, that they were going to they were going to find it and they were going to charge her with it. They held us for like over 30 minutes to get a dog there. The dog didn't hit on the car yet. They still searched the car, and now she's being faced with possession of a controlled substance. But where do they get by with there's no victim, there's no crime, and still trying to use statutes to indict people and charge them with it and send them to prison?
Yeah, so this is a complicated question, but I'm going to answer it as best as I can, and I hope that people listen to what I say here and can comprehend it. I apologize, guys. The way that I think is lofty, and when I say things, I assume that people understand what I'm saying because it makes sense to me. If you guys don't understand this, I'm not sure what we can do.
Call Jess and I'll interpret.
Call Jess and she'll interpret. So here's the history behind the state being the victim. Okay, this is the history behind it. Okay, the rulings that the United States Supreme Court put forward are not in the best interest of the people. They're in the best interest of preserving the business and the industry. We know that this industry is slavery because the foundations are rooted in slavery. The Fugitive Slave Act, right? The prisoner is a criminal in the 13th Amendment. So we know, or a slave is a prisoner in the 13th Amendment. So we know that the foundation of the system is rooted in slavery. And so what happened was that there was a civil war, right? Prior to the Civil War, slaves were owned by private parties. People owned the slaves. Those people took care of their slaves because it was their property, their asset, whatever. But then we fought this war and allegedly won this war to abolish this industry. And then we passed an amendment to the Constitution of the United States of America that says it doesn't exist anymore. And America went around saying, oh my God, slavery doesn't exist anymore because we lost 600,000 people to this in this war and so on. The 13th Amendment, for clarification, does not abolish slavery. What it should say, if it abolished slavery, is that neither slavery nor involuntary servitude shall ever exist within the jurisdiction of the United States. That would be clear. You can't have slavery. But what the 13th Amendment actually says is neither slavery nor involuntary servitude shall exist except as a punishment for crime. And the moment you say except, it means that you can have slavery, but it must be as a punishment for crime. So the problem is that before the Civil War, slaves were owned by private party. After the Civil War, the slaves were owned by the state because the state is adjudicating crimes. Prisoners go into work for a state-run business that directly benefits the state. So what happened with the 13th Amendment was it didn't abolish slavery. It simply retitled slavery justice and changed it from a private institution to a public institution. And then America said, oh, it doesn't exist anymore. But it absolutely does. State of Florida has 140,000 prisoners. Of those prisoners, the state contracts with General Dynamics to bring the prisoners in, the slaves in, to build General Dynamics chipset for their fighter jet. The prisoner doesn't get paid a cent. State of Florida does through the contract. That's not justice. That's slavery. And the slave owner just so happens to be the state of Florida. State of Florida also contracts with with Northrop Grumman and Lockheed Martin to bring prisoners in to answer the help desk phones. Those prisoners don't get paid a cent. State of Florida does, but not the prisoner. That's not justice. That's slavery. And the slave owner is the state of Florida. In the state of Georgia, we have the females that want to sew the tags on Victoria's Secret underwear, right? That's also, they don't get paid a cent. State of Georgia does, but not the prisoner. That's also not justice. That's slavery, and the slave owner just so happens to be the state of Georgia. So my point here is that the state became the slave owner. Well, the problem that the Supreme Court had in preserving this industry was that in 1865, the 13th Amendment was put in place. The slave owner became the state of whatever. They are responsible for adjudicating the crimes. They're responsible for making a person a criminal, to enslave them and force them into involuntary servitude so that the state can benefit off that labor, right? Well, the Supreme Court of the United States knew that only people can own property. Only people can own property. Corporations cannot. And the state is nothing more than a corporation. So if the Supreme Court wants to preserve the slavery institution, then Chief Justice Waite and his court had to put into place a whole bunch of rulings that would prevent the slavery institution from being exposed as justice. And the case Santa Clara County versus Southern Pacific Railroad was one of those cases that did just that. So what Santa Clara County versus Southern Pacific Railroad did was, before the oral arguments were read, right? Before the oral arguments were presented to the court, Chief Justice Waite made an arbitrary statement on the record that had nothing to do with the issue at hand, right? And what he said was, we, referring to the entire court, the United States Supreme Court, we are all under the belief that this corporation is protected by the Equal Protection Clause of the 14th Amendment. Now, that might seem pretty arbitrary to all of you. That might not seem like much of a statement, but that is a profound statement that has changed the trajectory of our justice system ever since then, significantly. Because only people can be protected by the 14th Amendment. Only the Constitution protects people. So when Chief Justice Waite made the statement that this corporation is now protected by the Constitution, he didn't make that ruling because it was the right thing to do, because Southern Pacific Railroad needed to be protected by the Equal Protection Clause. He did that because he knew that the state was nothing but corporations. So by saying that this corporation is now protected by the 14th Amendment, that created personification of corporations. Now corporations are considered people under that ruling. So because corporations are now considered people, that means that the state, being nothing more than a corporation, is now protected by the Constitution as well. It's personified. And now guess what? The state can be a victim against you, right? But the reason why they did that was not because the state needed to be the victim. The reason why they did that is because the state is a slave owner. And in order to protect the slave owner and therefore protect the slave industry, we had to make them so that they could lawfully own property. Because only people can own property, corporations cannot. Thus, they made that ruling not because it's the right thing to do, but because it protects their slave institution. And of course, slaves are nothing more than private property protected by the Constitution. Refer to Dred Scott versus Sanford, United States Supreme Court as well. So the answer is that this is a very, very complicated situation. But the maximum law, that if the corporation is a person, then that means that that body of law or that body of people is no different than one person, right? So the way that I like to point it out to everybody, and I'll do it with one hand here, but my body is a person, right? I have a whole bunch of different parts of my person. I have hands, I have eyes, I have ears, I have a head, I have a chest, right? All of these parts of my body make up the body of the person Tanawa, but they're all one. So if my hand goes out and steals something, my head can't say, oh, it was my hand that did it, you can't punish me. No, this part of the same body, Tanawa. So now let's extrapolate that into a state. If the state wants to be a person, If the state wants to be a person, that's fine. Then look at this. Consider my body the state of Washington. My hand is the prosecutor. My mouth is the judge. If my hand comes up to you and breaks the law or threatens you, intimidates you to force you to plead guilty, and then my mouth asks you, have you been threatened? This is one of the same body. The judge, the prosecutor, all represent a single body, because anytime the government comes at you as the person, then that entire body of men makes up one single body, one body. So all we have to do is we have to identify one crime committed by one part of the body. In other words, the police officer committed a crime. Therefore, the judge can't say, oh, it was my hand that did it. It wasn't, you can't punish me. No, it's the same body. So if we can identify one particular agent within the body of the state that committed a crime, that's where the issue of criminal conspiracy comes into play. The judge is part of the same body of men that's doing the threatening, right? Or doing the illegal searches or whatever. And that one body of men is now coming at you as a person. And because they're coming at you as a person, then that means that it's one. It's one once again. The whole entire body is one. So when the state of whatever comes against you as a person claiming to be the victim, then all we have to do is say, well, there was a crime committed right there when that judge acted out jurisdiction, and now the entire body must suffer and must pay for the crimes of that one single agent. That's where criminal conspiracy comes into play. And this also goes to Tort Claims Act. You guys want to go to your Tort Claims Act, which is what gives you the right to sue government. There are like 4 conditions that will allow you to sue government, right? Without immunity. It automatically waives immunity. One of those is if government takes action in a case, all immunity is waived. So no man can be judged in his own cause. So if the judge represents the mouth of the body, then that mouth can't speak on behalf of the entire body. Therefore, the issue that we're bringing to the Supreme Court is not, are indictment by a grand jury required? The issue we're bringing is, can the state or the body of men that make up the state be both accuser and judge in the same cause? And the answer is no, because they're one body, one single person, right? You can't break it up, state. You can't have it both ways. You can't claim immunity, but also take action in the case. So the issue that we have is, can a state be both accuser and judge in the same cause? But that's the history behind all of this. States are coming at you as the victim because the Supreme Court of the United States said that corporations are people and they were granted personhood. But inversely, in 1957, in the Brown versus Board of Education case, the United States Supreme Court came out with 5 requirements for personhood, and one of those requirements says that they must be self-aware. State doesn't meet the requirement for being self-aware, therefore they wouldn't meet the requirements that the Supreme Court has set out in 1957, Brown versus Board of Education, for being a person. So we do have to challenge the personification of the corporation, but it's going to be an easy one because, once again, that corporation is not a person. That was an arbitrary and capricious statement made by the Supreme Court, had nothing to do with it, but it's had profound effects on us now, because now the state is claiming victim because they were granted personhood in 1887 under Santa Clara County versus Southern Pacific Railroad.
So like you said earlier, I was listening, you said that when a person or a government entity uses intimidation tactics to get you to incriminate yourself, they have broken the law, right?
They violated the Constitution. The Constitution says, the self-incrimination clause, no person shall be compelled in any criminal case to act as a witness against themselves. Compelled.
And you can't do that in the court of law, right?
Yeah. So when the prosecutor comes to you and says, if you don't plead guilty, I will send you to prison for 20 years. Or if you don't plead guilty, I will add these other charges to you. Or I'm going to keep you in jail until such time as you plead guilty. All of those is an abuse of power. It is compelling you. It is threats or intimidation in order to get you to comply with them and to contract with them. But once again, in contract law, if the way in which the contract is formed is illegal, then the contract formed becomes illegal. And duress is a justifiable defense for a crime, a breach of contract, or a tort. So if they use threats or intimidation in order to get you to act as a witness against yourself through a plea bargain, that would be a violation of self-incrimination clause of the Fifth Amendment. No denying it whatsoever. But the other issue is, and a lot of people bring this up, is Yeah, but who determines whether or not you've been intimidated, right? You have to prove to that judge that you were intimidated. No, you do not. Intimidation is an inward manifestation, not an outward manifestation. I could walk in a courtroom and that judge could say, show me the scratch on your arm, but that judge can't say, show me the intimidation that you have. That is an internal manifestation, not an external. It is up to you to decide whether or not you were intimidated. It's not up to the judge. It's not up to the prosecutor. It's not up to the state. You yourself are the only one to know that did their abuse of power cause you to comply or even attempt to comply, because witness tampering is the same as witness intimidation. Just because you didn't actually enter into the contract of guilt, just because you managed to do it, if they tampered with you to cause you to not do it, that would be a crime in and of itself. So it's up to you to decide whether or not you've been intimidated. It's not up to the judge. It's not an outward manifestation. You can't go up to the judge and show them your intimidation because it's up to you. Same thing with their witnesses. If their witness...
It's on video where you can hear the cop telling them, if you hear the cop telling my wife, look, you better tell us, if you don't tell us this like this. But my other question is, I'll make it real quick. If the judge and the prosecutor and all of that, if they are the victim of a case, how do they get by with trying their own cases? Shouldn't the case go to the Supreme Court or to the federal courts, right?
It must. That's what so yeah, you're right. So the issue that we have, what we're actually litigating, what we're bringing to the Supreme Court of the United States to argue is, can a state be both accuser and judge in the same cause? Can the body of men that make up the state bring an accusation against you of having violated state law through one of their agents, a prosecuting attorney, and then be presumed to be neutral and biased, act as a judge against you? The answer is no. Just as Alexander Hamilton stated in the Federalist Number 80 that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. So if there's a dispute between the state and the citizens of the state, then the state can't be judged, because no man can be judge of his own cause. The body of men that make up the state cannot be presumed to be impartial and unbiased when the same body of men is bringing an accusation against you. Therefore, yes, the federal judicial authority of the Union must extend, and according to the Constitution of the United States, Article 3, that federal judicial authority is the United States Supreme Court. No other court in the country has personal jurisdiction to oversee a case in which the state is a party. Thank you.
A financial gain by these prosecutions or by these, being found guilty, right?
I'm sorry, I was answering another call. We got to move on to the next caller.
I understand. I do appreciate it. I keep following y'all. I wish I could contact you more and see what I can file on my own against this court.
Okay, thank you so much. Okay, the next caller, let's see, we have 1, 2.
Sorry guys, getting hot in
Next caller,
here.
are you there? They all hung up. Okay. They didn't want to wait, I guess.
All right. All right, guys. I think we're gonna get ready to start heading downtown. Meet with the Toll and Roll group there. So, if you guys like this, maybe we can do this another time when when we can have the air conditioner running and it's not so hot. It makes a bunch of noise. We're on time.
Oh, I see.
All right. So again, what we just did was we just served the state of Virginia Senate and House of Delegates with a notice that their budget that they are proposing for 2026 is going to be used to pay people to abridge their constitutional obligations. We have now served the state of Virginia's state legislature with the notice that if you approve the budget, if you move forward with it, that you will be paying people to violate the Constitution of the United States, and that is an emolument violation. So, state of Virginia is done to some extent. We still have a lot of counties to serve and a lot of cities to serve, but this was the necessary next step to escalate this up. That now places us one step below United States Congress on the hierarchy level. So all three branches of government have been served with notice in the state of Virginia: Attorney General, Supreme Court, and legislature. But we still have a lot of counties left to serve. So we need you guys' help in the state of Virginia to get out there, serve your local county, keep bringing this noise, and we'll take care of the rest. So thank you guys so much. This was the second service of 2026. We did Beaufort County, North Carolina on Monday, and we have a few more scheduled throughout the week. So thank you guys so much. God bless. Thank you for listening in and asking questions. Jessica, you got anything?
Love you guys. You're the best.
Okay, love you guys.
See you
You're the
soon.
best.
Bye.
Bye, TikTok. Thank you. All right. Thank you, YouTube. Appreciate it. God bless, guys. Thank you. Thank you.